Hello, uh, good morning to all of you, dear learners. Professor Madim Ali, Professor Department of Law, and your guide on the subject of Muslim law in India. Valued learners, first of all, I would like to introduce myself. As all of you are well aware about me, maybe well aware about me that I am Professor Muhammad Wasim Ali. At present, teaching in the Department of Law, AMU Aligarh for last 25 years. My area of specialization is family law as well as constitutional law. But for last several years, I have been teaching both Hindu law as well as Muslim law at the level of BLLB as well as PG level, that is LLM. And I'm also a guide of various research scholars who are doing their PhD under my supervision on the different theme and topics. I have already supervised about more than 10 PhDs on the different topics, but most of the topics uh, of the PhD under my supervision are related to the Muslim law, family law. Anyhow, currently I'm engaged with you on the topic of Muslim law. I have already discussed uh, different topics, that is sources of Muslim law, dawah, divorce, maintenance, guardianship, and extensively I discussed with great interest the topic of law of inheritance. I hope that during the discussion you have enjoyed as well as you have taken the keen and deep interest in the subject. Ladies and gentlemen, uh, it would not be out of place to mention here that subject of the Muslim law is of great interest. Reason because this subject basically speaks about the status of the person concerned. And therefore, as and when the status of any person is adversely affected, either by the act or by the words of any other person, or immediately the aggrieved person wants to knock the door of the court for the purpose of proper redressal from the forum of the court. In the recent years, you might have read the newspaper that various topics relating to the Muslim law are in controversy, or maybe divorce, procedure of the divorce, or modes of the divorce. Then, friends, maintenance, guardianship. These are the even to some extent. Muslim law of inheritance is also a point of debate both at the bar and bench. So, and therefore, even hijab and some other topics, they have been in controversy, and not only in controversy, but matter has gone to the highest court for the disposal or adjudication. And therefore, the uh, changes are taking place in the field of the Muslim law, because now the people are getting fully aware about their rights and privileges. Because marriage is a sort of contract between the two persons, I have already explained. And from this contract, various rights and obligations arise in favor of the parties concerned. Some of the rights are conferred on the husband, some of the duties are imposed on the wife, some of the rights, exclusive rights, are given to the wife by virtue of the marriage, and at the same time, some of the obligations are imposed as soon as the marriage is finally concluded between the two persons according to the procedure provided by the Muslim law. Since the contract of the marriage uh, gives rise to the reciprocal spousal rights and obligation. Therefore, in the event of the breach of either of the right of either spouse, it gives rise to the litigation from lower court to the Supreme Court. And therefore, friends, in the course of the time, uh, various issues have gone to the court of law, and the decision has been given by the court to in the light of Islamic jurisprudence, in the light of the pristine Muslim law. And therefore, now, as the society is advancing, rights, people are becoming right conscious. Since the people are becoming the right conscious, and therefore this subject is becoming more and more interesting as well as important. Now, friends, as all of you are maybe aware that earlier there was a controversy. What is the nature of Muslim marriage? Either it is a contract, civil contract, or it is a sacrament. And not only this was a point of controversy relating to the Muslim law, but even the same controversy was relating to the nature of the Hindu marriage, the nature of the Christian marriage. But in the course of the time, the courts have finally settled that every marriage is a is in the nature of civil contract. If not purely civil contract, but at least it is in the nature of civil contract, because the rights and obligation arising from this contract are in the nature of the civil rights. Since the rights are of the civil nature, and therefore the contract of the marriage has been finally held as the contract in the civil nature. Friends, I have already discussed that for a longer time, uh, the divorce or the dissolution of Muslim marriage has been a controversial, most controversial subject, because it is understood that under Muslim law only husband has got the power to dissolve the marriage. It is the unilateral power of the husband. Wife has no say in the dissolution of the marriage. In the course of discussion, I have tried to clarify that according to the Muslim law, marriage is a bilateral contract. Since it is a bilateral contract, therefore both the parties have got the right to separate from each other under a given situation. So as the husband has got the power to dissolve the union of the marriage under certain circumstances, on certain grounds, by and large, under the similar circumstance and on the same condition, even a Muslim wife is also given the right to put to end the contract of the marriage. And in this way, now it is settled that under Muslim law, right to divorce is not only the exclusive right of the husband, but it is a bilateral right. It is that this right is also available to the Muslim wife. What is the difference? Difference is only in the mode of pronouncement of the divorce. That husband himself can pronounce a divorce, can put to end the marriage, repudiate the marriage, whereas the wife can seek the dissolution of the marriage either from the husband himself or by order or by the decree of the court. Friends, the mode of the divorce, this has also been a point of controversy and has generated interest in the mind of the younger people of the society, that what are the different modes of the dissolution of the marriage as recognized under Muslim law. And even the court has also given the verdicts regarding the modes of divorce. Now, after the decision of the Supreme Court in Shaira Banu case, now only there are two recognized mode of the divorce. Earlier there were three in number. Talaq Ahsan, Talaq Hasan, and Talaqul Biddat are triple divorce. Now in Shaira Banu case, the triple divorce has been declared illegal and void. It is no more a form of the divorce. Even law has also been enacted, Muslim Women Protection of Rights on Marriage Act 2019. And therefore, now there are only two recognized modes of the divorce, that is Talaq Ahsan and Talaq Hasan. And these are the two modes in the exercise of the which only the husband can pronounce the divorce. The wife can seek the dissolution of her marriage in a different way by different modes. I have already discussed. Friends, I have already discussed some other topics like will, waqf, gift, and law of inheritance, Muslim law of inheritance. And I have tried to generate interest the learners in the subject that I have already discussed, and hope that all of you would have enjoyed discussion, and you might have learned a lot of so far as various aspects of Muslim law are concerned. Because Muslim law basically is part of the social system. It is a customary law. And this law is based by and on the customary rules which were prevalent before the advent of the Islam, but they have been uh, formulated after necessary reform therein, and now they are in the form of Muslim law or Muslim personal law. Uh, to certain extent, on certain subjects, certain topics are covered under the Muslim law, not entire things, but only a limited number of the subjects are included within the meaning of Muslim law according to Section 2 of Sharia Application Act 1937. And I think I have tried to discuss all those topics in detail, and you would have enjoyed the discussion when it was taking place. Now, friends, uh, many questions have been asked by the learners during the course of during the process of teaching, and now I will try my level best to answer all those questions to the satisfaction of the learners, so that all the misgiving and confusion may be clarified. So the first question that has been asked by Mr. K. Majid, and the question of learner is regarding the status of dower in muta marriage. Muta marriage. Am I audible to all of you? I hope so. Friends, as you may be fully aware that muta is a temporary form of the marriage. This form of the marriage, this is a customary form of the marriage and was very much prevalent before the advent of Islam in pre-Islamic customary Arabian society. It was purely a temporary marriage. Marriage for a fixed term, marriage for a fixed period of time. And on the expiry of the time fixed by the parties for the marriage, marriage automatically dissolve and parties automatically separate from each other. Now the question of the learner is what is the status of dower in muta marriage? It must be noted that in muta marriage, dower is must. Some of the essential conditions of muta marriage are that it must be the term of the or the duration of the marriage should be fixed before the marriage. At the same time, uh, it is also essential for a valid muta marriage that amount of the dower should also be fixed. Amount of the dower also should be fixed. If the marriage has taken place without fixing the duration and without fixing the dower, then such marriage will not be such muta marriage will not be a valid form of the marriage. Therefore, fixing of the dower is one of the essential condition for the validity of muta marriage. And wife of a muta marriage is legally entitled to receive the amount of the dower agreed upon between the parties concerned either before the marriage or at the time of the marriage. In case the husband fails to pay amount of the dower fixed with their mutual free consent, then wife of such marriage will be entitled to file a civil suit invoking section 9 of civil procedure code and can claim this amount of the dower the amount of the muta marriage dower, as any creditor can file a suit for the recovery of his or her unpaid debt. So the dower in muta marriage is just like a unsecured debt, and the wife is entitled to get it from the husband. In case husband fails to pay it, then and he dies, then the wife will be entitled to recover the amount of dower from the property of her husband. So this is the obligatory part of the muta marriage, and wife is entitled to receive it from the husband. In case the husband dies without making the payment, she will be entitled to recover it out of the property left by the deceased husband. Uh, Friends, so far as the concept of marriage in pre-Islamic Arab was concerned, is concept, because the other question is whether the concept of dower was also uh, in pre-Islamic marriages. Of course. Friends, before the advent of the Islam, Arab was a customary society. Being in a customary society, their uh, social institutions were also regulated by customary rules. So was the case with the marriage. Before Islam, a number of the customary marriages were known in pre-Islamic Arabia. Bina form of the marriage, ball form of the marriage, cigar marriage, muta form of the marriage. These were the well-known customary form of the marriages prevalent in the, different tribal societies. One of the customary, well-known customary form of the marriage prevalent in some of the tribal society of the Arab was Bina marriage. In Bina form of the marriage, it was basically a sort of the arranged marriage, family marriage. According to this custom, Bina custom, any person who was interested in marriage, he would make a proposal of the marriage to the parents or guardians of the girl. And in order to secure the consent of the guardians, for the marriage of their daughter with the proposal that is the prospective husband. The prospective husband or bridegroom would make the offer of some gift to the parents, that is to the guardians or to the parents of the girls with whom one was interested to marry. So, the gift which was offered by the prospective husband to the parents of the girl, so that they can give consent or agreement for the marriage of their daughter. Basically, that very gift originally was called as dower. So, this made by the prospective husband to the parents or guardians of the uh, bridegroom, would be bridegroom, was originally called as dower. But it was in some of the tribes, this type of the practice was only in some of the tribes. At the same time, in some of the tribe, according to their custom, rule was that if anybody was interested to marry with a particular girl, he would approach to the parents of the girl, would make a proper offer to marry with her, and in consideration of the marriage, he would also make the offer of some gift in the form of money or other property. But according to the custom, whatever gift was offered, that basically that was given to the wife herself, not to the parents or not to the guardian. Because in some of the tribes, the offer of the gift was given to the parents, to the guardians, just like a sale price or purchase price. It was just like purchase price, but it was also called as a dower. But at the same time, in some of the tribes, custom was that if anybody was interested to marry with a particular girl, he would approach to the parents or the guardian, uh, will discuss with them, and in case the guardians agree to marry their daughter with the particular person who was approaching to them, then the prospective husband will give something in the form of the gift, maybe cash or maybe a property. But this gift was directly offered or given not to the parent but to the girl or to the bridegroom herself. And this gift basically was called as dower in proper sense, because this Veena form of the marriage basically was a proper form of the marriage. According to the customary society of the Arab, actually this was a regular form of the marriage, considered as a most regular form of the marriage. And therefore, in Veena form of the marriage, in some of the tribes, according to their custom, husband would make the offer of some gift to the wife herself, and the offer of the gift which was made by the husband to the wife, that was originally called as dower. So basically, the concept of the dower in either form was very much in fashion, was very much in prevalent, particularly in Veena form of the marriage. Therefore, concept of the dower, of course, is rooted in the Veena customary form of the marriage, and therefore idea of the dower is basically based, idea of the dower in Muslim law is basically based on the customary concept of the dower, which was prevalent in Veena form of the marriage before the advent of Islam. Third question is reference book material demand in form of the question to provide the material by Abnas Pujari.
Provided so.
So I will provide it, no problem. Uh, we will post the material and you will get. Question number 4. Uh, whether Kabina Nama and Nikah Nama is same or different. Ladies and gentlemen, this is a registration certificate, you can see. A marriage registration certificate. So, under Muslim law, basically, marriage certificate is called as Nikah Nama or Kabina Nama. This is the uh, Arabic word, and from the Arabic word, this idea is so basically, Kabina Nama and Nikah Nama, they are one and same. There is no difference in letter and spirit. Both are one and same. In both, the detail of marriage is mentioned so that in future, if there is a dispute regarding the validity of the marriage, it can be submitted as a documentary proof of the fact that marriage between the two persons had taken place. Marriage was valid or invalid. This can also be assessed on the basis of this certificate. Therefore, Kabina Nama and Nikah Nama both are a kind of the marriage certificate, and both are available in a due form, in a pro forma, and this is also called as marriage certificate, duly certified by the person who performed the nikah of the parties concerned. Then next question is whether a Muslim marriage shall be valid witnessed by 4 females in place of 2 male witnesses. Ladies and gentlemen, uh, I would fetch your 1 minute and attention. Uh, One must remember that in Muslim marriage, even a marriage can be performed without witnesses. In the absence of the witnesses, marriage will be simply irregular, not void. But uh, to make it perfectly regular, valid, it is necessary that it must have been witnessed by a requisite number of the competent witnesses, persons. A requisite number of the witnesses for a valid marriage is that there must be 2 witnesses. If both are male, uh, then their number should be 2. If one is male and 2 are female, so meaning thereby requirement of the witness is again fulfilled. Now the question is that where all 4 are female, whether married will this requirement of the witnesses stand fulfilled or not according to the rules of the Muslim law. I would like to clarify that what Muslim law requires that it must have been witnessed by 2 males, and if it is witnessed by all witnesses are all female, then there must be 4 females. 2 females for the purpose of marriage are equivalent to 1 male witness. Therefore, if all 4 are female witnesses, then requirement is fulfilled and condition of the witnesses is fulfilled and marriage will be perfect. So all 4 can be a competent witnesses for the performance of a valid marriage. No problem. All 4 may be females, provided they fulfill other relevant conditions. That is, they must be seen, they must be of uh, must have attained the age of majority. If they are fulfill these basic conditions and all are female, marriage will be perfectly valid. So all 4 can be competent witnesses. Next question. is available with me is if both the side make their presence virtually, video conferencing, will it be considered one meeting? Yes, of course. Now it is settled. There is a consensus of the opinion among the jurists of the Islam that if online marriage is taking place and the voice of the parties is certified or testified by two independent and competent witnesses, then it will be considered as offer and acceptance taking place in one and same meeting, and marriage will be valid. Legally it will be valid. There will be no problem, there will be no legal ill consequences. So uh, marriage online is permissible. Only condition is that a person who is giving the offer and person who is accepting the offer, their voices must be testified by the two independent witnesses available with them on the sites if the marriage is taking place online. And now the next question and the last question as sent by the learners is what shall be the legal status of the same-sex marriage as per Muslim law? Ladies and gentlemen, uh, according to the Muslim law, marriage means uh, marriage between the two persons of the opposite sex or opposite gender. Means for the formation of the union of the marriage, Muslim law requires, Islamic jurisprudence requires that one must be male and other must be female, along with other conditions. But the so far as the sex is concerned, both the parties must not be of same sex. They must be of opposite sex. Proposer may be male, acceptor may be female, proposer may be female, acceptor may be the male, but one must be male and other must be female. This is the first and foremost prerequisite of a valid Muslim marriage. And therefore, under Muslim law, according to the Muslim law, if both the parties are female of same sex, marriage will not be a valid marriage. If both the parties are male, marriage will not be a valid. It will not be considered as marriage because notion of the Muslim marriage perceives that one must be male and other must be female along with some other conditions. Therefore, same-sex marriage under Muslim law is not recognized. It is not valid if the two peoples of the same sex, they are living together as a husband and wife, they are behaving like a husband and wife, they are doing everything like a husband and wife. That may be a living relation under the some other laws, but this living will not confer the status of the husband and wife on the parties, because under Muslim law, marriage confers a status. As soon as there is a marriage has taken place, there is a union has been concluded. So on the conclusion of the union, it will confer status, a legal status, and status that it will confer the status of husband on male and status of the wife on female. And on the basis of this status, they are entitled to the reciprocal rights and obligation against each other. Wife is entitled to maintenance. Wife will be entitled to the dower. Wife will be entitled to cohabit with the husband. So the husband will also be entitled to the right to the cohabitation. Some other rights are conferred on the husband. So uh, basically under Muslim law, marriage means union of the two persons of the opposite sex, opposite gender, opposite. If they are of the same sex, it will not be a marriage in the estimation of Sharia law, in the estimation of the Muslim law, and this stand is consistent even though in India, same-sex marriage uh, is the concept of the same-sex marriage is going on, uh, but even the court has also not granted, has not accepted because recently matter was before the Supreme Court. Government of India itself has opposed the same-sex marriage, and therefore same-sex marriage is neither permissible under Muslim law nor under Indian law. Only the live-in relation or live-in relations is recognized under the secular by virtue of decision of the Supreme Court, subject to certain conditions. But same-sex marriage is neither recognized under Muslim law nor recognized under the Hindu law nor under the Christian law. Even under any law, same-sex marriage in India is not allowed till date. The question. So, ladies and gentlemen, respected learners, any more question from the topic, from the subject, which anybody wants to know, or on any sub point, anybody wants any sort of the clarification? So, you please come forward, ask the question, and we will discuss the question in detail so that our point may be fully clear. So, any more question from anyone?
Uh, Good morning, sir. May I ask a question?
You are allowed to ask the question. I am here.
Yes, sir. So myself, Kazia. I have this one question, sir. The talaq pronouncement. There is no clear data. How should the pronouncement be? Should be in the form of words written, or what is an appropriate or the most approved form of the pronouncement? Because there is one case I think pending about the Benazir Hina case where she got her talaq e Hassan through mails. So, is there any clarity on that, sir?
Uh, Respected learner, your question is very valid and sound question. Uh, so far as the pronouncement of the divorce is concerned, it must be noted that divorce can be pronounced by the husband oral or in writing. Both are allowed and both are valid, have the valid effect so far as the effect is concerned. Therefore, a Muslim husband can dissolve the marriage by making the oral pronouncement of the law. He can also put to end the marriage, contract of the marriage, by pronouncing the talaq in writing. So both oral divorce can be given and divorce can also be pronounced or given in writing. Therefore, communicating the divorce through the mail is also covered by the divorce in writing. And therefore, according to the procedure, if the divorce is communicated to by the husband to the wife even through the mail, that will also have the effect of dissolving the marriage according to the Muslim law. So, pronouncement of the divorce even through mail is also uh, valid and will have the effect of finally dissolving the marriage. Right? So far as the modes of the divorce are concerned, I think you are also wishing to know. Now, after the pronouncement of judgment by the Supreme Court in Shaira Banu, opinion of others. Now, triple divorce is no more a valid form of the divorce. It is illegal and void in view of Section 2 of Muslim Women Protection of Rights on Marriage Act 2019.
Hmm.
And therefore, at present, there are only two recognized mode of divorce are talaq, and they are talaq ahsan and talaq ahsan. So these are the only two valid formula of divorce in the exercise of which a Muslim husband can divorce his wife. So he can pronounce the divorce resorting to the formula of ahsan, or he can pronounce the divorce upon his wife uh, resorting to the formula of Hassan. So both are valid right now, though the Hassan formula of the divorce is also contested, is pending before the Supreme Court. There are grounds for challenging it, but right now both the formulas are regarded as a valid form of pronouncing the divorce so far as the Muslim husband is concerned.
Okay, sir.
Right?
Thank you, sir. Thank you.
Yes, sir. Myself, Vikram. So my question is,
Yes.
sir, when there is a dispute regarding mode and manner of divorce, so the question is, if there is a dispute whether the divorce given is right or wrong, regular, irregular, or batil, then which is the forum which decides these disputes? Either
Uh,
it's the family court or the civil court.
uh, okay. Now you see that so far as the validity of the divorce is concerned, that is that can be challenged before the family court, and family court will decide, because now earlier it was civil court, civil judge, senior division and junior division both were having the power, but now the family courts have been established, and therefore special jurisdiction is conferred on the family courts, and therefore family courts will decide the validity of the divorce pronounced by the husband, whether divorce was pronounced properly or it was improperly. That will be decided by the family courts.
Yes, sir. So my question was pursuant to your just you just said that so far as the recovery of dower under muta marriage is concerned, you have to go to the civil court. So if we go to the civil court for recovery of dower, then whether there is a
Yes,
dichotomy or
yes, yeah. Very, very, very relevant question. Now you see that so far the mode is concerned, decides basically the status of parties. Because when divorce is challenged, meaning thereby status is to be decided. Whether parties have separated from each other, they are having the status of the husband or wife or not. So status of the parties is decided, can be decided by the family court. Substantive, this is the substantive matter. Now, so far as the dower is concerned, basically dower is a sort of claim arising from the status of the marriage. So claim can be this dower can be claimed from the civil court, because section 9 of the CPC confers this jurisdiction on the civil court.
thank you, sir. Thank you.
Okay. Any more question from anyone?
So just it's not related to the subject, but it's related to the mode of exam. So what kind of examination we will be giving final examination? It would be a like regular university examination, or it would be like MCQs like this.
You see that, of course, this exam means exam, as is conducted by the universities, colleges, and even the university and colleges, they are also having the different modes of the exam. In some of the universities, uh, long question, long answer is required in some of the universities. Long and short and semi-short question are answer are required. But we will conduct our online this in your case. The entire exam will be MC.
Thank you, sir. Thank you.
So any more thing from anyone? Feel free, because today is Sunday and we are sitting after a long time. So if any new question is sticking to your mind and you are we want to seek the clarification, because it is a very diversified field. So far as the Muslim law is concerned, and day by day some controversies are coming before the Supreme Court and High Courts. So, any question? Because even the last time I was engaging the class, and one of the young student from my class, he asked a question, sir, should there be any upper age limit in case of the marriage across the board? A very relevant question. Because now with the change in the society, now he was feeling and he was giving the data, though it was limited data, and he came out with a question that now in the society, due to some financial consideration and some other considerations, now a man of 65 years, 75 years age is marrying or getting married with a girl of 20 years, 25 years for different reasons. And after marriage, a lot of the problem arise, dispute arise, and then matter goes before the court of law. Different type of the litigations are filed, and now not only society is adversely affected, but even the system is also getting overburdened due to this reason. So why there should not be upper age limit even in case of the marriage? Now, second question, that there should be some age nexus between the husband and wife, meaning thereby that there should be a reasonable age gap. There must be a reasonable gap, not one-sided gap, that husband is of 60 years and girl is 20 years, or girl is 65 years and husband is 20 years. So this type of, so why not? Of course, this may be a future problem. Because in some of the societies, this type of the things are happening, problem is coming, society is facing. Now system will also face this type of the things. So now it is a good proposal that there must be some age limit, and not only the age limit for because if a person of 80 years is marrying, the women may be 65, but object of the marriage, purpose of the only companionship is required, or some the object of the marriage is something beyond the companionship. So all these things are considered under consideration, maybe come up before the Supreme Court or High Court. And so now any question, any other concept, problem if you are having in the mind, you can ask.
Sir, good afternoon, sir. This is Tahir Nisa. Good morning.
Huh? Good morning.
Yes,
Good
sir.
name?
In
Good name?
Tahir Nisa.
Tahir Nisa.
So, as in this concern in Dower, like previously, if the wife is not working, then they used to give this dower and all these things. Now the women are also working in the society, right? They are also doing jobs. They are also at the higher positions. After divorce, will they get this dower nowadays also, or is there any rule that working ladies should not get this dower because they can stand with their financial, they are earning their financial, all those things like that?
Yes. Answer of your question is that dower under Muslim law is essential incident arising out of the contract of the marriage in view of the Humaira Bibi versus Zubaida Bibi and other cases.
Oh,
It is essential incident.
oh,
to the status of the marriage. Basically, it is the legal consequence flowing from the contract of the. As soon as a marriage is concluded,
Hmm.
wife becomes automatically entitled to the amount of the marriage might have been fixed between the parties before the conclusion of the marriage or at the time of conclusion. So, concept of the dower under Muslim law is not linked with the status of financial status of the wife,
Okay.
financial condition of the wife. Rather, it is linked with the contract of the marriage.
Oh,
Marriage is a contract, it is an agreement between the two parties of the opposite sexes. As soon as this agreement gets the final shape, because of this contract, some rights flow. From this contract, some rights flow, and one of the rights flowing from the automatically in natural course flowing from the contract of the marriage is right to dower. So
okay.
right to dower is natural legal consequence following the contract of the marriage that has been already held by the Privy Council in Humaira Bibi versus Zubaida Bibi, and it is not linked with the status of the wife. Even at the time of the marriage, wife may be very, very rich, even sometime more than husband, more
Oh,
than family of the husband. But wife cannot be deprived of this right, which is the natural contractual right of the wife flowing from the contract of the marriage.
okay. Okay. Thank you, sir.
Okay.
Thank you so much.
But here again, I wish to make some more clarification
Yes.
that even in context of the maintenance,
Uh,
under section 125 old CRPC, now it is perhaps 141 under the new code. A wife is entitled to the maintenance from her husband. And here wife means any wife, maybe Muslim, maybe Hindu, maybe Christian. A wife will be entitled to the claim of maintenance only if she is unable to maintain herself out of her own personal financial resources. All of you may be well aware about the nature and scope of section 125, old section 125. Now it is 141, perhaps new, under the code of BNS, not BNS, but Bharatiya Nyaya Suraksha Sanhita.
okay.
Well, but under Muslim law, pure Muslim law, financial status of the husband is not relevant for the purpose of awarding the maintenance. A Muslim wife, if is neglected, refused maintenance by her husband, she will be entitled to claim it from the husband irrespective of her financial status. She may be in job, earning good amount, but since maintenance is also one of the spousal rights flowing from the contract of the marriage, it is a very natural right, it is very natural spousal right of the wife. And therefore, even if she is able to maintain herself, even then she is entitled to maintenance from her husband, having regard to the status of, and therefore husband is under the legal obligation to pay maintenance to his wife according to his available financial resources, regardless of the financial status of the wife. But under 125 earlier, 141 new code, the maintenance right of the wife is subject to the financial condition of the wife. If she is poor, unable to maintain herself, only then she will be entitled to claim the maintenance. So I think that person, even under Hindu law also, this is not a condition. Under section 18 of the Hindu Adoption and Maintenance Act 1956, a Hindu wife is entitled to maintenance from her husband, irrespective of her financial condition. only condition has been attached in section 125. So I think that a right which is natural right of a wife, why it should be subject to certain condition? Because the wife is entitled to dower under Muslim law simply because of being the wife, being legally married to him. Wife is entitled to maintenance or simply because a relationship has been established between two persons. So because of a relation, she is entitled to certain rights, and these rights are independent rights of the wife, not subject to any condition so far as the Muslim law is concerned. But these rights have been made subject to certain conditions under the secular law, that is section 100 of 125, and now it is section 144 of the BNSS. So now it is subject, it should be revisited that even maintenance should not be subject to the condition that if wife is unable to maintain, only then she will be entitled. If say for example, but now if the wife is earning, or say for example she has secured a job in the government sector, so it is because of her own labor, because it is the fruit of her own labor, her own skill, her own devotion, her own dedication. So why her earning should be linked with her right? So far as the maintenance right is concerned, it is an independent, exclusive right of every wife flowing from the contract of the marriage. It has no link with the status of the wife. It is linked with the status which is conferred by the marriage. And therefore, I think, personally, I feel, and all of you, since all of you are a budding lawyer, and therefore you can go to the court of law and can challenge it. You can write on it this, that the right to maintenance, which is subject to certain condition under the BNSS, earlier under section 125, that if unable to maintain herself. So I think this condition precedent is not a good condition, is not a valid condition, and it should be set aside. This right of the maintenance should also be independent right, because it is independent and exclusive right of the wife.
So don't you think it will be creating Pandora box that just because the wife is getting married to a man and then the maintenance will flow for all times to come? So it would be,
No.
prejudicial.
I don't think this is not Pandora box. This is the common right. This is the common right. Pandora box means that if any new problem is going, this is not a problem. Marriage is not a problem, and rights arising from the marriage are also not a problem. They basically they bring the peace and order in the society. They will make the marital life or spousal life more comfortable, more easy. So how do you think that this is going to open the Pandora box? Means that this is going to create social disorder? Why?
No, sir, what I mean to say was
Because
that, sir, what I mean to say was that till the time, in the period after divorce, then they have the right to claim maintenance despite their financial independence. But
you are
after it,
talking you are talking about a different situation.
yes,
I
sir,
was talking about a different situation.
yes.
Perhaps you did not understand my question. That in a normal course of circumstances, if a wife may be Hindu or may be a Muslim, if deprived of neglected the maintenance right, that is a different question. Maintenance during the Iddat period is a different aspect of the problem.
All right, sir, all right.
Okay. Any more question?
Sir, if you have time, I have a follow-up question of this things here which you suggested.
Yes, sir. I have time. I have time. I have time. Please come out. Huh? Come forward.
Uh,
Huh.
sure. So one thing you have put in here is that you personally feel that irrespective of the wife's financial status, the husband should maintain her. I think that was the underlying score of that, sir. And
Yes, 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 yes.
and then this was something you suggested during the course of marriage, if I'm not wrong, sir.
Hmm?
This suggestion is for during the course of marriage, not after.
Yes, 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 yes. Yani,
Yes, sir.
during the continuance of the marriage, during the continuance of the marriage, wife should be entitled to the maintenance independent of her financial condition and right. This is my submission.
Yes.
Whereas under section 125, wife can claim the maintenance if she is unable to maintain herself. Are you getting my point?
Yes,
But
sir.
my
I
submission
got
is
it, sir.
that during the subsistence and continuance of a wedded marriage, wife should be given or should be allowed to claim the maintenance independent of her financial earning, financial resources, because this is the independent and exclusive right of wife flowing from the specific contract, that is the contract of the marriage.
Yes, sir. It sounds fair too, because in Islam, in Islamic law or the Muslim law, the accounts, the finance of a woman's is her own, and she's not accountable to anyone. So this
Yes.
suggestion, what you make, is like within that law. So I have my follow-up question is, I heard that there is. I'm not sure about the maintenance law 125, which you are telling, not in detail, sir, but there is this term in the government which says that the husband has to maintain the wife according to his financial status. There cannot be a fixed amount which every husband has to pay for a wife. Rather, whatever his strength is, based on that, the maintenance will be allotted. Now, if a woman can afford herself, if she can maintain herself, but yet the man, the husband she was married to, is of a higher financial status, he comes from a higher financial background. Like, for instance, that is how the societies are at the moment, sir. There is a pay disparity happening. Men's by default earn more. They are in a more professional background. Women who are like, yes, who can sustain themselves, are also like undergraduates who are making just 20K a month, and husband is making 2 lakhs a month. Yes, the wife can survive with that 20K. But if we just take out that one third or one fifth of the husband's uh, amount into an account, the maintenance code will go higher. Do you think the court should actually consider that too, sir?
Now courts are considering there is no limit to the amount quantum of the maintenance is concerned. Now the courts are awarding the amount of the maintenance having regard to the financial status of the husband vis-a-vis requirement of the wife. And requirement here means that what is required for the dignified survival of the wife, because so far the survival means dignified survival in a given circumstance. So whatever material things are required in a given circumstance for a dignified survival of a person in a given condition, basically the amount of the maintenance should be fixed according to this. So the courts are deciding. Now, therefore, there is no limit to the amount of the dower. Earlier it was that maintenance cannot be more than 5,000, but now this limit has been set aside. Now the courts are awarding the maintenance having regard to the financial condition of the husband, as well as requirement of material requirement of the wife in a given circumstance. Requirement of the wife is to be calculated having regard to her dignified survival. So whatever is required for the dignified survival even in a given society, in a given circumstance, the quantum of the dower will be subject to this. And therefore, it may go up to anything, even maybe in thousands, maybe in hundreds. It depends upon the attending financial condition of the husband, attending financial circumstances of the wife wherein she is placed.
Okay, sir. Thank you,
Right?
sir. Yes, sir.
Okay. Anyone else? Okay. Should I wind up? So, ladies and gentlemen, thank you very much for being with us. If any more question, you can ask it online and I will reply you. ठीक? Even on telephone, you can call me. Okay. So with this, once again, I thank all of you to be with me online in the question answer session. And pursue this course seriously. It will benefit a lot to you in future. Because in future the scope of the subject will widen further, and it will have a lot of scope in practical as well as in the professional life. Thank you very much.
Thank you very much, sir.